Law has been the stuff of civilization, the glue that holds society together since the days of Moses. Today, however, the rule of law is under scrutiny and lawyers themselves are under siege. Lawyer bashing is the province of many, from late-night comics to politicians. Justified or not, this barrage of criticism has eroded public trust in the entire legal profession. While many in the profession complain about the situation, the American Inns of Court is doing something about it. The American Inns of Court is a nationwide network of more than 13,000 judges, established and younger attorneys, third-year law students, and legal scholars dedicated to improving law in and out of the courtroom. Since 1980, in light of ever-increasing demands on the legal profession, the American Inns of Court have provided one of the few forums where members of bar and bench work together to reclaim and transmit the goals of the profession and a love of the law. The enthusiastic response within the legal community has made the American Inns of Court one of the nation's fastest-growing legal organizations. The mission of the American Inns of Court is to foster excellence in professionalism, ethics, civility, and legal skills within the bench and bar. The American Inns of Court adapts the centuries-old system of legal apprenticeship in the English Inns of Court to the needs of our contemporary American legal system. Each American Inn is composed of 3 membership categories. Masters of the bench are judges, experienced trial attorneys, and law professors. Barristers are attorneys with 3 to 15 years litigation experience. Associates are lawyers with less than 3 years litigation experience, or pupil members who are third-year law students. An American Inn consists of between 40 and 80 members with approximately equal representation from each member category. Within each Inn of Court, the members are divided into pupillage teams consisting of 2 or 3 members from each membership category. Each pupillage team is responsible for conducting 1 demonstration or program per year during the Inn's regular monthly meetings. Programs put on at an American Inn meeting or nationally at the organization's annual meeting provide a lively way for members to observe and discuss pertinent legal issues and to examine their own values and judgments in an increasingly complex profession. For more information about forming or joining an American Inn of Court in your community, contact American Inns of Court, National Office, 127 South Peyton Street, Suite 201, Alexandria, Virginia. The telephone number is 703-684-3590.
It was over 100 years ago that Lawyers Cooperative Publishing first recognized the void in cohesive legal research information required by attorneys. The year was 1882. The major obstacle to legal professionals of the day was the need to travel long distances by horse and buggy to conduct tedious, time-consuming research. The goal of Lawyers Cooperative Publishing was simple: to make the practice of law easier and more efficient by making much-needed research tools readily accessible and the research itself more efficient. In that year, when the first volume of our U.S. Supreme Court Reports, Lawyers Edition, rolled off the presses, that goal became a reality. Since that first publication, thousands have followed. Today, Lawyers Cooperative Publishing provides lawyers in every state with a totally integrated system of legal research which reflects the company's mission: to analyze the law in order to make the process of legal research more productive and less time-consuming. Today's products, ranging from ALR and AMJUR to federal procedure and state-specific case reports, jurisprudences, and specialty practice guides, continue to analyze with depth, clarity, and authority the important legal issues of our times. That analysis, which is the very essence of our system, separates us from other legal publishers. At Lawyers Cooperative Publishing, we don't just report the law. We put it in perspective with expert, practical analysis that gives attorneys exactly what they need in their daily practice: the edge.
Good evening. I'm Robert Spitzer. On behalf of the Leo A. Deegan Inn of Court, I'd like to welcome you here to Department 22 of the Robert Presley Hall of Justice in Riverside, California. The Leo Deegan Inn is one of over 220 Inns of Court across the country. made up of over 13,000 judges, lawyers, and legal scholars who gathered together to promote ethical and professional standards in the practice of law. Typically, members of an inn will gather together on a monthly basis to discuss issues associated with the presentation of cases in court. They will also discuss the ethical and professional problems that confront lawyers in the representation of clients in what is admittedly an adversarial system. The problem tonight deals with the selection of jury in a civil personal injury case. A jury made up of private citizens drawn from the community is one of the most distinctive features of the Anglo-American legal system. The right to a jury trial is so important that it finds its protection in both the Sixth and Seventh Amendments to the United States Constitution and the constitutions of 49 of the 50 states. In most jurisdictions, a pool of potential jurors is assembled from lists of automobile drivers, property tax holders, registered voters, and occasionally from public assistance roles. Individuals are summoned into court. They take an oath and are asked to tell the truth and are subjected to questioning. Again, in most jurisdictions, the court will collect some basic information from each individual and then permit the attorneys to continue the questioning. This is a process known as voir dire, a rather poor attempt to speak French, but which quite literally translated means to speak the truth. The information obtained in the course of this questioning will be used by the attorney to establish a basis to excuse a potential juror for cause. That is where the attorney is able to establish some form of irredeemable prejudice on the part of the juror. It may also provide the basis for a peremptory challenge, which requires no explanation from the lawyer. It is important to note at this time that not all the information communicated is verbal in form, and that skilled lawyers look for other cues as to what a particular juror may be thinking on issues that relate to a decision in the case. Communication in this setting is not a one-way street. The lawyer may be saying or doing things which precondition the individual juror to favor or ignore the case which the advocate wishes to present. As with all communication, this is largely an intuitive art form. It requires the advocate to have, at the beginning, a total conception of what he or she is going to accomplish in the courtroom, how all the pieces of evidence, law, and argument fit together. Our hypothetical case this evening involves several claims of personal injury damages filed on behalf of the plaintiffs, Pedro Padilla, and members of his family, against his employer and landlord, Major's Farming Empire. As in all trials, the details are important. Pedro Padilla was born in 1960 on a lettuce farm in the Coachella Valley in the far eastern portion of Riverside County, an area that is predominantly desert. There, he lived with his parents who labored as migrant workers. Padilla has completed the equivalent of the 9th grade at various migrant schools throughout the state of California. Since 1978, he has been employed on a full-time basis by Majors. Initially as a laborer and equipment operator in various lettuce and tomato operations, later as a field foreperson, where he receives an hourly wage of $9.87. Padilla has been an active member of the United Farm Workers Union since 1978. At the age of 18, Mr. Padilla married Maria Perez and established a home and quarters that had been provided by the defendant, Majors. Padilla and his wife have 3 children, Juan, age 12, Irma, age 10, and Jesus. Between 1984 and 1991, when Jesus was born, Maria suffered 6 miscarriages, usually fairly late in the term. Jesus suffers from Mongolism. There is no history of similar birth defects in any of the other children within the family. Neither Juan nor Irma exhibited any health problems at birth. However, in 1986, both children, along with others which resided in the same housing complex supplied by the Major's operation, began to experience persistent and unexplained bouts of nausea, headaches, dizziness, and skin irritation on a regular basis, particularly during the late spring and early summer months. Medical expenses associated with the miscarriages and the children's emergency room visits have so far totaled $10,500, which was paid by the state insurance provider, Medi-Cal. Postnatal care of Jesus, including oral surgery, which was used to correct a cleft palate, so far has totaled $50,000, which was also paid by Medi-Cal. Medical experts will testify that individuals who suffer from severe Mongolism of the kind exhibited by Jesus have an average life expectancy of 20.6 years, and anticipated future and medical expenses might be somewhere in the $500,000 range. Major's Farming Empire is an agricultural concern which is incorporated under the laws of the state of Delaware. It was incorporated in 1969. It operates lettuce and tomato farms in California, New Jersey, Delaware, and Texas. All stock is closely held by members of the Major family, who in turn comprise all the officers and corporate board members. This business was founded here in Riverside County in 1937 in the Coachella Valley, when its Morton Major bought 50 acres from the government, drilled a well, and began to raise tomatoes and lettuce. In 1992, the Coachella Valley holdings approached 5,000 acres, including the original property and well and a housing tract where the Padilla family resides. Since 1980, the corporation has provided housing and utility service at reduced rates to some of its employees, including Mr. Padilla and his family. The business has employed migrant farm workers since 1939 and was the object of striking UFW workers during the period of 1965 to 1970. Also important in this case is another individual named Alberto Corleone. Mr. Corleone was doing business as Alberto's Petro Fill-Up and began selling gasoline and diesel fuel along Highway 111, approximately 1 mile from the Major's farm, in 1945. Over the years, the business expanded to a garage and a truck stop, including a small cafe, and 6 underground fuel storage tanks, each with a capacity of about 50,000 gallons. For years, waste oil and other toxins were disposed of in a French sump which was located on the 5-acre parcel. In 1978, Alberto retired and he closed the business. In late 1989, inspectors from the California Departments of Agriculture and Health Services discovered the existence of the storage tanks. During the course of the removal in early 1991, it was discovered that 5 of the tanks had ruptured, contaminating local groundwater sources, including 4 of the 8 wells on the Major's farm. Also of importance is that during the period of 1970 through 1989, the California Departments of Agriculture and Health Services initiated periodic programs of aerial spraying to combat Mediterranean fruit flies, which were located and infesting the Coachella Valley. Dr. Peter Guber, a PhD in chemistry and staff chemist for the Department of Agriculture and a witness for the defense, has stated and testified in his depositions that the aerial application of malathion poses, quote, substantially no risk to public health, close quote. Other witnesses may be called, including Dr. Ana Sanchez, who is an associate professor of medicine at the University of California, San Diego campus, and a fellow at the Salk Institute in La Jolla. She has examined all the members of the Padilla family and has detected abnormally high levels of lead in the blood of each. Her stated opinion is that Jesus Padilla's Mongolism is the product of chromosomal damage suffered by one or both of his parents, which was the product of lead or other heavy metal poisoning. Another witness is Dr. Cruz Zorzal, who's a medical doctor from Salinas, California. He has testified before legislative committees in both Sacramento and Washington, D.C. in favor of stricter controls over pesticides and herbicides used in the agricultural industries. He has spoken to gatherings sponsored by the United Farm Workers Union on the dangers of exposure to farm chemicals. He holds the opinion that malathion and a number of chemicals utilized to control pests on the major's farm present a substantial danger and create illnesses symptomized by headaches, dizziness, nausea, and skin irritation. And he believes that they cause birth defects. Some of the pesticides used before 1988 by defendant majors contained lead or other heavy metals. At this point in time, I would like to introduce the attorneys in the case. The attorney for the plaintiff, Pedro Padilla, is Stanley O. Orrock. Mr. Orrock completed an undergraduate degree in rhetoric and public address at the University of California, Santa Barbara campus in 1965. He went on to graduate studies in aerospace management at the University of Southern California as part of his work as a captain and pilot with the United States Army. In 1977, he completed his legal education at the University of La Verne and was admitted later that year to the California State Bar. Mr. Orrock is a senior partner with the firm of Fiddler and Bell in Riverside, specializing in the field of government tort litigation. He recently defended the County of Riverside in a multi-million-dollar suit brought by local citizens over the operation of a toxic waste disposal site known as the Stringfellow Acid Pits. Currently, the Stringfellow case is the largest Superfund cleanup case in the country. Representing the defendant, Major's Farming Empire, is David G. Moore. Mr. Moore graduated with a bachelor's degree in business from the University of California, Berkeley in 1961 and went on to complete his legal education at Hastings College of Law in 1964. Mr. Moore later that year joined the law firm of Reed, Babbage & Coyle, and that firm later merged with another firm in San Bernardino County, becoming the firm of Reed & Hillier. He is currently the firm's senior litigation partner, specializing in areas of bankruptcy, real estate, and business litigation. He served recently as the president of the Riverside County Bar Association and is currently the president-elect of the Leo A. Deegan Inn of Court. The court at this point in time will call the case of Pedro Padilla versus Major's Farming Empire. Mr. Orrock, is the plaintiff ready to proceed?
Yes, Your Honor.
Mr. Moore, is the defense ready?
Yes, Your Honor.
Thank you. Ladies and gentlemen, good evening. You've been summoned to this courtroom, Department 22, in order to answer questions that may be posed to you to determine whether or not you may sit as fair and impartial jurors in this particular case. At this point in time, before we begin asking you any questions, I'm going to ask that you all stand, raise your right hand, and take an oath to tell the truth. If you would raise your right hand. Do you and each of you solemnly swear to well and truly answer all questions that may be asked you, touching on your qualifications to act as fair and impartial jurors in the cause now pending before this court? If so, please say, I do.
I do.
Now I'd like each of you to answer some questions giving me some basic information about yourself. I'd like to start with Ms. Shelton and then work down through jurors number 2, 3, 4, all the way through juror number 8. I'd like you to state for me your name, state the city or the portion of the county in which you reside. I'd like to know what your marital status is, and if you are married, how many children you have and their approximate ages. I'd like you to describe for me your employment history and the name of your current employer, and if you're married, your spouse's employer. And finally, if you've had any prior jury experience, I'd like you to tell me about that. How many cases, when, and where, and the kind of cases. So if we could begin with juror number 1, Ms. Shelton, could you answer the questions I've just asked you?
My name is Jennifer Shelton. I live in the city of Riverside. I am married. I have 2 children. One is 5 years old. One is 3.5. Currently, I take care of my children at home, and I also do some babysitting for some other people. My husband owns a home inspection business, and I have never been on a jury before.
Have you ever worked outside of the home?
Yes, for a time I worked as a bookkeeper in my husband's business, and prior to that, on and off, for several years, I worked in a counseling center for troubled children.
Thank you. Juror number 2.
My name is Mike Fortino. I live just outside the city of Riverside, near University of California, Riverside. I'm single,
My wife,
fully employed by the University of California at Riverside, is an associate professor in history. I previously taught at the University of Chicago, University of Maryland. I've also been a consultant to the United States government, McDonald's corporations, and several weekly publications.
Do you have any prior jury experience?
None.
Juror number 3.
I'm Herbert Williams. I live in Riverside. I'm married. I have 3 adult children. I work as a office manager at a financial services office. I've done that for about 20 years. Before that, I had a newspaper distributorship, and before that, I was in the Army. My wife is a bookkeeper at a rental car agency. I've served on one jury. It was a criminal case
How long ago?
2 years ago.
Do you remember the nature of the charge?
It was a burglary charge.
Was the jury able to arrive at a decision in that particular case?
Yes, we convicted the guy.
Juror number 4.
Your Honor, my name is Craig Reamer. I'm a civil engineer, live in Corona. I'm married. My wife is a public health nurse for the County of Riverside, and I've never been called for jury duty.
Thank you, Mr. Reamer. Juror number 5.
Your Honor, my name is Robert Ramirez. I live in Riverside. I am married. I have 2 children, one age 15 and one age 18. I currently own a 25-acre citrus ranch here in Riverside. I have for 5 years. Before that, I was the foreman on a citrus ranch in the San Joaquin Valley for 25 years. And before that, I was a long-haul trucker. My wife is a homemaker, and I have no prior jury experience.
Thank you. Juror number 6.
My name is Irving Eakes. I am married, have 3 children, a daughter 44, a son 42, and another daughter 39. I am retired from the University of California as a plant physiologist there, starting with the Citrus Experiment Station in 1952. Let's see. My wife is a homemaker, and I have never been called for jury.
Thank you. Juror number 7.
My name is Elizabeth Toby. I live in Riverside. I'm married. My husband's name is Ron. I have 2 children, Amy, my stepdaughter, and David. David's 10, Amy's 22. I'm self-employed. I have my own business. I'm a CPA. My husband works at UCR Riverside. He's a professor in the history department. I've been on one prior jury. It was a civil case.
Thank you. Juror number 8.
My name is Kathy Christmas, and I live in Riverside. I'm married, and I have 2 children, ages 6 and 12. I've been a registered nurse for the past 20 years, and I'm currently working at Kaiser Hospital in Fontana. My husband's a librarian, and I've been on 3 juries before.
What kind of cases were those, Ms. Christmas? Civil or criminal?
They were all criminal.
Okay. And in what courts?
The last time was in a federal court, and the other 2 were here.
Do you remember the nature of the charges in any of those cases?
2 of them had to do with drugs, and one was a rape case.
Do you recall if the jury was able to arrive at decisions in any of those cases?
Yes, all 3.
Mr. Orr, would you care to inquire of this panel?
Yes, thank you, Your Honor. Please, the court, counsel, ladies and gentlemen, Your Honor, may I approach the podium?
Yes, you may, Mr. Orrick. You may breach the well.
Good morning, ladies and gentlemen. As the court has indicated to you, we are now in a process called voir dire, and that means, as the court has indicated, to tell the truth or to speak the truth. The questions that I'm about to ask of you are not intended to be disrespectful. However, we are trying to find a jury which is unbiased, that has no prejudice, and who can be impartial. In order to do that, there are certain questions that we need to ask concerning your personality, concerning your occupation, and things which may bear on your bias or your prejudice. So if you will forgive us if we tend to be prying, but it's only for the purpose of getting an impartial jury. Ladies and gentlemen, I am pleasured to represent Pedro and Maria, Juan, Irma, and Jesus in this matter. The Padilla family has worked and lived on the farm operation of the Majors farming empire since approximately 1978. During this period of time, Majors has used pesticides containing leads and heavy metals as part of their program of agriculture to ensure that their crops can be brought to market. As you know, my clients have 3 children, the young of which suffers from Mongolism. Maria has also had 6 miscarriages. All of them suffer other types of ailments and injuries. And I say this only to give you an idea of the kinds of problems that you're going to be confronted with if you're selected to serve on this particular jury. Let me ask first of all a general question. Do any of you believe that this is an improper type of case to bring before a court of law and have this dispute resolved by each of you sitting in judgment, not only of my clients, but the defendant in this action? Do any of you believe this is an improper case?
Please answer out loud, ladies and gentlemen.
No.
No, I do not.
Let me ask a question of the panel again generally. Have any of you been raised in a state other than the state of California?
I have, sir.
Yes.
Okay. Mr. Fortino, what state have you been raised in other than California?
Do you want me to include countries too?
Well, if you could, sir.
Michigan, Nebraska, Mississippi, New York, and Europe.
Okay. Mr. Williams?
Texas, sir,
Mr. Williams, how long did you live in Texas?
until I went off to college.
So that would have been the first 18 or 19 years of your life?
Yes, sir.
What part of Texas did you live in, sir?
Beaumont.
In Beaumont, Texas, is there a large Hispanic population?
Yes, sir.
All right. Have you developed any prejudice towards Hispanics as a result of being raised in Texas?
I was being raised in Texas, sir.
Have you developed a prejudice against Hispanics based on any other experience?
I've had some trouble with some Hispanic employees.
And when was that, sir?
When I had the distributorship, some of my drivers.
Okay. Mr. Eakes, you've also indicated that you were raised in a state other than California?
Yes, I was raised from 4 to about 22 in Colorado.
What part of Colorado, sir?
I was in the western slope at Delta.
Ms. Toby, you've indicated that you also have been raised in a state other than the state of California?
Yes.
What state is that?
New York State and Great Britain.
Thank you. Have any of you worked on a farm as part of your adult life or childhood? Okay, Mr. Ramirez?
Well, I was a foreman on a farm in San Joaquin for 25 years.
That's right. While a foreman on the farm in San Joaquin, did you use pesticides as part of your program of growing the crop?
Yes, sir.
Did you ever use malathion for any of your crops there?
Yes, sir. We use those safe kind of pesticides like
All right. Did any of your pesticides include lead?
I don't know the answer.
How about heavy metals?
I don't know, sir.
As part of your job as foreman, did you have contact with the United Farm Workers Union?
Sir, I participated in a class action lawsuit when I was in my capacity as owner of the citrus ranch that I own now against Sunkist for price fixing, and in regard to that suit, I did have some contact with the farm workers.
What was the nature of the class action suit that you brought, Mr. Ramirez?
It was for price fixing.
For price fixing. How would you describe your relationship with the United Farm Workers?
It's been very good.
Mr. Akes, you indicated you also worked on a farm at some point?
Yes, I grew up on a small farm in western Colorado, general things, and my father became ill when I was about 12 and was partially running it myself until I got out of high school.
What was the nature of your father's illness, if I might inquire, sir?
He had a sinus problem developed from working in a hay mill where they ground hay, and it clogged up his sinus and knocked him out.
What kind of crops did you grow on your farm?
We had tomatoes, beans, corn, had some peaches and berries, and also a few livestock.
Did you use any pesticides as part of your farm operation, sir?
Yes, sir.
What type of pesticides did you use?
These were pests to control the insects, primarily in the beans and tomatoes.
Did you ever use DDT as part of your pest eradication program?
No, sir. It was
Did
not
any-
available at that time.
Were any of your pesticides, did any of your pesticides include lead or other heavy metals to your knowledge?
Yes, sir.
They did? Okay. Ms. Toby, did you also work on a farm at one time?
Yes, my father had a 400-acre farm in upstate New York.
What kind of crops did you grow?
We grew soybeans, alfalfa, corn, wheat, oats. We raised pigs and black Angus cows, had some sheep, and a small orchard.
Do you know whether pesticides were used by your father in this operation?
I don't know. I was a child at the time, and I remember on occasion my mother would make us stay indoors when the planes were crop dusting, but I don't know if they were my father's or someone else's.
Have any of you in your occupation had contact in the work environment with lead products? How about malathion? Has anyone had it? Miss Christmas?
Well, just X-ray, having to do with X-ray.
Okay, x-rays. And Mr. Ramirez?
We used malathion on the ranch.
Right. Mr. Reamer, you say you live in Corona, and Corona has obviously in the recent past been part of the medfly eradication program in the state of California and has been sprayed with malathion. Have you been part of the opposition group at all to the use of malathion in the Corona area?
No.
Have you formed any opinions or conclusions as to the safety of malathion based on the eradication program in the city of Corona?
I'm not worried about it.
Do any of you currently have any union membership?
No.
Are any of you smokers? Mr. Fortino, how long have you been a smoker?
18, 20 years.
Mr. Fortino, as a smoker, you have obviously been exposed to the Surgeon General's warnings concerning the use of cigarettes. Has that caused any concern to you about your continued use of cigarettes?
Not really.
Other than Miss Christmas, do any of you have any special training in the area of medical sciences?
No.
No.
Miss Christmas, you indicated you're a registered nurse at Kaiser. What department or division do you work in?
In the critical care area.
As part of the critical care treatment at Kaiser or program at Kaiser, do you deal with patients who have been exposed to toxic materials causing injury?
Yes.
And what type of toxic materials have you been involved with in your nursing capacity in treating patients?
just recently Jimson weed, people that have taken or ingested toxic substances,
Okay.
either intentionally or inadvertently.
All right. Do any of you have special training or education in the area of chemistry?
No.
Mr. Eakes?
Yes, I am a plant physiologist, and through that we have to have some knowledge of chemistry, both organic and inorganic chemistry.
In your former capacity as a plant physiologist, sir, did you use pesticides as part of your agricultural experiments?
We used chemicals such as fungicides to control decay on citrus. I worked with post-harvest, so I worked with the fruit.
Oh, so you were working more with the fruit than you were with the actual plant growing.
That's correct.
As part of that program with the fruit, were you involved with pests such as the Mediterranean fruit fly?
I was not involved directly in that. I worked on the control measures, in other words, the quarantine treatments to be able to ship fruit out of here in case it was established.
Have you recommended the use of malathion as an eradication product for the Mediterranean fruit fly?
That is not within my realm of concern.
Okay. Have you been involved at all with the decision process utilizing malathion for eradication?
No, sir.
Sir, thank you. Ms. Shelton, let me ask you, how do you currently dispose of toxic materials in your home?
Really don't come across that many toxic materials.
Have you had any pesticides that you've bought for the use around your home in the gardens and for your plants?
My husband takes care of the outside. I take care of the inside of the house.
Okay. So such things as paint and pesticides, acids that may be used in the house as normal cleaning products or for the purpose of maintaining the home, those are disposed of by your husband?
Yeah, I know we have some paint cans in the garage, but as to anything else, we're just real careful because we have young kids around the house.
Ms. Tobey, how about you? How do you dispose of toxic materials in your home?
Well, the city has a program where every now and then they'll put an ad in the newspaper saying you can put out your old paint or whatever, and they come around and collect it.
Do you
Otherwise,
think,
it just sits there.
you think that's a good program?
Well, it saves me a trip to the dump, so, yeah.
Before the city started that program, would you take your materials to the dump?
Well, my husband takes care of that, and I'm not sure what he did with them.
Do you have 2 children at home? Do you take any particular caution to keep toxic materials away from your children?
Yes.
What do you do?
Well, when my son was small, we put child-proof locks on all the lower cupboards, of course, and medicines and things like that we keep out of reach.
Have any of you been exposed to any substance which has caused you nausea? Ms. Tobey?
Paint, fresh paint particularly, varnish, that kind of thing, dry cleaning fluid.
And what have you done when you've had those kinds of experience where you become nauseated because of fumes from particular types of products?
Well, I try to leave the area as quickly as possible, go somewhere else.
Has your exposure ever caused you to seek medical advice or treatment?
Not directly, no.
Mr. Fortino, you say you've also had experience with nausea as a result of being exposed to some type of toxic material.
Well, ether.
And what did you do when you were exposed to the ether?
Left the chemistry lab.
How about headaches? Do any of you suffer from headaches on a regular basis?
Yes,
Ms. Sheldon, you do?
yes.
How often do you have headaches?
2 to 3 times a week.
Has the source of that headache process been determined by any medical physician?
Nobody's really sure what it comes from.
Anyone else suffer from headaches on a regular basis?
Yes.
Mr. Williams?
I get them occasionally when I'm dealing with bureaucrats and trying to fill out the paperwork.
Okay. And Ms. Christmas, you also indicate you have headaches?
Yes.
How often do you have them?
Oh, they're seasonal.
Are they a result of allergies?
Yes.
Okay. How about dizziness? Do any of you suffer from dizziness? Mr. Fortino?
Heights.
Heights cause you to become dizzy?
Yes.
This is addressed only to the ladies. Have any of you suffered miscarriages?
No.
Have any of you given birth, live birth to any child with a birth defect?
No.
Yes.
You have, Miss Christmas. What birth defect have you had with your children?
Congenital heart disease.
Do any of you know of the business known as Major Farming Empire?
Yes.
Okay. Ms. Toby, how do you know Major Farming Empire?
Well, some of my clients are in the farming business, and I just know that they're a rather large landowner down in Coachella.
Do you do work for people who are in the farming business?
Yes, accounting work.
And Mr. Reamer, you've indicated that you also know of Major's Farming?
Just from the newspapers, the owners are very active in the political arena, and I've seen them mentioned in connection with fundraising for campaigns and such.
Okay. Do you know of any of the principals in that business, personally?
No.
Do any of you do business with Major's Farming directly?
No.
Let me change the subject for a moment, if I might. Do any of you have a philosophical or religious or cultural belief that limits your ability to award damages should the evidence in this case warrant damages on behalf of my client? In other words, do any of you have a preconceived notion that there is a dollar sum above which you will not grant damages in a case of this type?
No.
So if the evidence were to support a damage in a let's say $1 million, would that offend anybody, or would that cause you to believe that because of religion, culture, or personal belief that you could not award that kind of money should the evidence support that kind of an award? Okay.
Sir?
Yes, Mr. Eads.
Yeah, I believe that that there should be substantiation to the need for that amount of money. Granted, some pain and suffering, but I think some of these awards are a little beyond realism as far as the real damage that has been done to the person.
Can I assume, sir, that that philosophy is largely dependent upon news articles and other reports that you've read about large verdicts being awarded for things that you believe to be inconsequential?
Yes, sir. And part of it is that I realize I have not had privy to the information of justifying those large amounts.
If the evidence were such that it, and the court will tell you ultimately that there is a burden of proof, it's called a preponderance of the evidence, and that we have the burden of proving our damages, and if we shift the scales of justice ever so little in our favor, then we have, by a preponderance of the evidence, carried our burden of proof. If the evidence does preponderate in our favor, sir, would you be willing, if the evidence also supports the damages, to award whatever sum is reasonable in this matter?
Yes, sir.
Okay. Thank you, sir. Thank you, Your Honor. I have no further questions.
Thank you, Mr. Roy.
Hi, Susan. How was your vacation?
Great, but short.
Better than long and lousy.
You're not kidding. I had a client who went to Aruba for 2 weeks. What a nightmare. We ended up having to sue his travel agent.
Oh, come on. I never heard of such a thing.
Seriously, and we collected too. I had read some similar ALR articles, and the facts fit, so we decided to go with it.
ALR, that's a case finder, right?
Well, it's really more than that. It not only finds relevant cases, but it provides an analysis on the subject. Essentially, it provides a good legal brief on any given topic, so you can quickly understand what you need to know.
Well, they couldn't have much on lousy vacations. Pretty obscure.
Well, you'd be surprised, Sam. There were 7 or 8 different ALR articles, each containing a specific angle of travel liability. They were all cross-referenced, so when I tapped into the travel agent article, I found a lot of related ALR articles in case law. They even broke them down state by state.
And you found that here?
No. I have it on my CD-ROM on my computer in my office.
Introducing Lawyers Cooperative Publishing's new Law Desk ALR on CD-ROM. The leading resource for conducting thorough and comprehensive legal research, ALR on CD-ROM gives you instant desktop access to thousands of thoroughly researched articles, providing authoritative analysis on any legal topic. ALR on CD-ROM is easy to use. Just type your search and immediately see the results. ALR's advantage lets you instantly check to find the relevant ALR article, with all your search terms highlighted. To find out how Lawyers Cooperative Publishing's Law Desk ALR on CD-ROM can instantly put relevant case law at your fingertips, call 1-800-828-6373 and ask about our free training right in your office.
Mr. Moore, would you care to address any questions to this panel of jurors?
Yes, I would, with the indulgence of the court. Thank you, Your Honor.
You may breach the well as well.
Thank you. May it please the court, ladies and gentlemen, the prospective jury, opposing counsel, I believe this morning you have heard what this process is all about. Neither my opposing counsel, Mr. Orrick, nor I intend by any of our questioning to ask you anything that may embarrass you. What we're trying to do here through this process is obtain a level playing field. In other words, a jury that can be as fair to Mr. Orrick's clients as they can to my client. Now, my client is a corporation. That's a legal entity, and corporations, we all know, just could be big and they can be small. This one is a rather large corporation. Now, in addressing a general question to you all, is there anybody that's seated in the box currently that would have a problem with sitting on this jury just because my client happens to be a corporation that's engaged in the business of growing agricultural crops?
No, sir.
Can you all treat a corporation fairly just as if you can treat an individual fairly?
I think so.
All right. Now, is there anybody here currently seated in the box that feels just because a claim has been filed by the Padilla family for personal injuries, that just by filing of the claim that somehow they should recover some money without proving their case?
No, sir.
Some of you have sat on juries before. Do you understand that the plaintiffs in this case have the burden of proof by a preponderance of the evidence? And His Honor will tell you what a preponderance of the evidence is. Mr. Orrick referred to it. It's a tipping of the scales. That you understand that the plaintiff has the burden of proving the case by a preponderance of the evidence on the issues that the plaintiff has to prove to recover. Do you all understand that?
Yes.
Yes.
All right. Does anybody have a problem with that concept of our law?
No, sir.
No.
Is there anybody currently seated in the box that feels that there's too many lawsuits brought currently in our state, that there's a lot of frivolous litigation or people are filing too many lawsuits?
Yes.
Sure. So would you raise your hands, those of you that feel that there's being too many lawsuits filed in our state?
That's about everyone.
All except the lawyers.
Do your feelings in that connection, would they, assuming you are allowed to serve on this jury, would any of you that have feelings in that connection that too many lawsuits are filed, do you feel that that would affect your ability to be seated here for the couple of weeks that this case is going to be in trial, to hear the evidence and render a fair verdict just because you have some feeling that too many lawsuits are filed?
No, sir.
No.
All right. Now I'm going to ask some individual questions of some of you. And I'll start with Mrs. Shelton. Mrs. Shelton, your husband owns a home inspection business. What is that all about? What, in essence, does he do when he inspects homes?
He checks for things like the structural stability of the home, the roof, plumbing, visual type things that he could see.
Checks for termites and that sort of thing?
No, he doesn't do termites.
As a consequence, how long has he been engaged in that business?
He opened his own business 4 years ago. Prior to that, he worked for another business for about 3 or 4 years doing that.
All right. So for at least the last 7 years or so, he's been doing that type of work?
That's right.
Who was his prior employer before he became self-employed in his own business?
It's called American Home Inspection.
All right. And where was that situated? Was that situated here in the Riverside area?
They had an office out of the area, and then each of the inspectors kind of just worked out of their homes. I think they were in like San Francisco or something like that.
All right. At one time you worked outside the home before you had young children as a bookkeeper, and you also at one time worked with troubled children. I'm interested in hearing what was your work with troubled children, what was that all about, and how long ago was that?
That was after I graduated from college. It was a group home. I didn't stay at the home. The trouble they were having would be either with families or drugs or something like that. I didn't stay at the home. I would just go for counseling sessions with the children several times a week.
And what was your educational background in regards to counseling?
I have a degree in sociology.
And were any of these troubled children, did they have any sort of birth defects or other defects that could have been genetic in origin?
No.
All right. Let me ask a general question of the panel before I pass on to Mr. Fortino. As you've heard from His Honor about the statement of the facts of this case, what it's all about is that it appears that one Alberto Corleone ran a service station about a mile from my client's place of business on Highway 111, which was called Alberto's Petro Fill-Up, and also a cafe. That was run for a period of time from about 1945 to 1978 when it was closed, and that in the early part of 1989 various storage tanks were identified as still being in the ground, in other words, gasoline tanks. In 1991, they were evacuated from the ground, in other words, taken up, and it was found that several of those tanks had ruptured over the years. Have any of you ever, let me ask you this, do any of you, your family, or any of your close friends to your knowledge know Alberto Corleone, or anybody that may be connected with Alberto's Petro Fill-Up?
No.
Mrs. Shelton?
We have some relatives in New York who know a family by that same last name, but I don't think that they're related to anybody in California.
All right. Mr. Fortino, let me ask you this, sir. You work in Riverside as an associate professor in the history department, and you've also lived in Europe, and you do consulting work. Is that correct, sir?
I have, yes.
What kind of consulting work?
As a historian and my knowledge of the former Soviet Union and Russia in terms of their industrial development.
Is there anything connected with your consulting work in which you consult on anything having to do with chemicals or with toxics or with, for example, gasoline products?
Yes.
And in what connection, sir? Can you explain that?
When I worked for the McDonald's Corporation, one of the things we looked at was whether or not the Russians produced the type of agricultural products that they would need to open up a restaurant. And while I was aware of it, I didn't personally work on it. One of the issues was a type of chemicals that were used in treating the particular crops that were being grown in Russia or the Soviet Union that would ultimately make it to the marketplace by McDonald's.
And what did you learn about the chemicals in that regard? Were you given instruction about what type of the chemicals were being used, or did you study that yourself, or how did that come about?
Well, I was aware that there was some question as whether they used types of chemicals, insecticides, herbicides, in manners that would not be consistent with the customer practices of the Americans.
Anything about that experience that in your mind would weigh for or against any of the parties in this case?
Not necessarily.
And when you say not necessarily, what do you mean by that, sir?
Well, I'd like to hear what the evidence is before I make an ultimate decision.
You'd keep an open mind and hear the evidence both from the plaintiff's side of the case and the defendant's side of the case before you made a decision in that regard, wouldn't you, sir?
Sure.
Now, did any of you, your family members or close friends to your knowledge, ever had anything to do with the gasoline distribution business or in the manufacture or refining of gasoline products, or, for example, running a cafe or restaurant where there's a gas fill-up?
Yes.
No.
All right. Let's start with Mr. Reamer. What is your experience in that regard, sir?
Well, my first job out of, after I got my engineering degree, was working on the construction of a refinery in Texas.
And how long did you work on that refinery?
3 years.
Did you learn anything about gasoline products as a result of working on the refinery? I take it you did, sir. You're a civil engineer.
Well, I wasn't involved in designing the plant. I was supervising a cement batch plant there that was,
right.
But I had some classes that dealt with the refining process in general, but not in detail.
Were you made aware that back in those days, at least, lead was used in gasoline?
Not through that context, but through seeing it on the gas pump in those days, sure.
Just general knowledge.
Yeah.
What kind of civil engineering do you do generally?
Mostly bridges, streets, pipelines particularly.
As an adjunct to your engineering on pipelines, are you familiar with the way liquids move through the ground through hydrology?
Not greatly, no.
You understand that liquids such as petroleum products or other liquids can move through the ground with groundwater, sir?
Sure.
Let me ask you, Mr. Williams, when you were running your distributorship back in Texas, you were also connected, I take it, with the trucking end of moving those newspapers?
It was not in Texas, sir. It was here in Riverside.
All right,
and
sir.
The trucking end of it, the publisher delivered them to me, and then I had drivers who distributed them to the individual homes.
Did you deal with gasoline products in that connection?
No, I had a credit card where the guys could go fill up their cars.
All right. When you were in the Army, sir, what was your MOS in the Army? What did you do there?
I was an infantry officer, platoon leader. I
And-
also was a special advisor to Arvin.
And what particular theater did you serve in and what years?
Vietnam. I did first tour in '65, and then as a special advisor in '68.
You were in Vietnam. Were you exposed, either you or your troops, to any what may have been toxic substances? You've heard of the Agent Orange problem.
I'm not aware of it. We dealt with the enemy by a nice artillery piece.
Thank you, Mr. Williams. Mrs. Toby, have you ever acted as an expert witness as a CPA?
No, sir.
Your husband's with the University of California at Riverside, is that correct?
Yes.
Also in the history department?
Yes.
Does your husband know Mr. Fortino?
I think they know each other professionally.
Do you know Mr. Fortino?
I think I've seen him around the department occasionally, but beyond that, no.
Okay. Not social friends.
No.
Does your husband do any consulting work outside the university?
Yeah.
What kind of consulting work does he do?
Well, he's worked on some EIRs, and he worked on the Citrus Heritage Park. He prepared the history of the citrus industry that the docents use to prepare their talks for the park when it opens. He worked on the Jensen Alvarado Ranch. He's got a couple of contracts with the state for old military bases to do some work there. He has consulted with the Los Angeles County Museums.
Anything about his work in doing EIRs where he's worked with engineers or consultants about toxic problems that have come to your attention as being his wife that he's discussed with you?
I think on some of the citrus stuff he talked to some engineers about farming practices and what measures were taken to protect farm workers, that kind of thing. But it's rather vague. I don't remember specifically.
Skipping back to Mr. Reamer just a minute, sir, your wife works as a public health nurse. What does she do in that regard? I understand what a nurse does, but specifically, what's her assignment?
Primarily working on communicable diseases of teenage mothers, at-risk infants, seeing whether there's a family support system for when an at-risk infant leaves the home or leaves the hospital and goes to the home.
Nothing in connection with toxics, for example, like Mrs. Christmas works in the emergency room in the sense of critical care unit where she cares for people that may have been poisoned, for example, like she said, by Jimson weed or some other toxic substance. Your wife doesn't do that type of work.
Not that I'm aware of. I think part of her survey of a home situation may be evaluation of whether there's a risk of exposure to lead from old paint, but that would be about the extent of it, I think.
All right. Mrs. Christmas, your husband works as a librarian, is that correct?
Yes.
And where is that?
At Norco.
And what kind of library? Is that the public library?
Yes.
Does he have any interests in terms of hobbies or that brings him into, say, anything having to do with engineering or the toxic waste field?
No.
Just a general librarian?
Yes.
What did he do before he became a librarian, if you know?
He was in the Coast Guard.
And how long was he in the Coast Guard?
For 4 years.
And before that, what did he do?
He was a student.
All right. And you've been a registered nurse for over 20 years with Kaiser, is that correct?
I've been a registered nurse for 20 years, but not all the time with Kaiser.
And before you worked at Kaiser at the critical care unit, what kind of nursing experience did you have before that? Generally the same kind that you were in critical care, or did it differ?
Critical care and medical surgical nursing, all hospital-based nursing.
And did you work in other areas other than the Riverside area?
Yes, in San Jose and in New Orleans.
Thank you. I have no further questions of the Veneri at this time. Thank you, ladies and gentlemen. I'd pass for cause, Your Honor.
Thank you, Mr. Moore.
Your Honor, the plaintiff also passes for cause at this point.
At this point in time, each of the attorneys has an opportunity to excuse a number of jurors. For the purposes of our exercise, each attorney will be granted 2 peremptory challenges, and what I would ask them to do is simply to indicate the identity of those jurors that they may choose to strike peremptorily, and then to offer a short explanation as to why they did what they did. Mr. Orrick?
Thank you, Your Honor. Your Honor, the 2 jurors that we would dismiss and thank for their service would be jurors number 2, Mr. Fortino, and juror number 3, Mr. Williams. The profile the plaintiff has in this kind of a litigation tells us that the worst possible juror is generally a white male over 50 who smokes and is involved in management. The best profile that we anticipate for this jury is a female between 25 and 40 with children, environmentally sensitive, some college education, with a husband who is underemployed. So that's what we're basically looking for. In Mr. Fortino's case, the fact that he has been a consultant in the agricultural area, particularly in Russia, for McDonald's, and is a smoker who for 15 to 20 years without any concern whatsoever as to the Surgeon General's status of smoking leads us to believe that he fits our worst profile. Our concern with Mr. Williams deals with his problems of employees who were Hispanic. We did not develop that as much as we would have had we had more time, but that is a concern of ours as it relates to Mr. Williams. Also the fact that he was basically raised in Texas, which would tend to lead us to believe that there may be a bias towards Hispanics. So that's the basis upon which we would have challenged those two jurors.
You indicated that you have some kind of profiles, Mr. Orrick. Where do those come from?
Well, the demographic profiles come from experience, I think, as much as from any place else. It's a matter of trying to determine, and what we attempt to do in all cases prior to selecting a jury is to determine what is our best and poorest profile for a juror, whether it's a slip and fall case or it's a case involving quadriplegia. We know certain things of jurors. For example, jurors who smile tend to be more sincere than those that don't. People who speak to us with their hand over their mouth tend to indicate that they're hiding something. People who change their answers tend to be deceptive or attempt to display discomfort. Extreme smoothness, and Mr. Fortino fell into that category, is typically an insecure person. People who are relaxed and lean forward are the type of jurors that we believe are truthful. Nurses tend to be harsh, and we use those kinds of body language and presentation to determine the things that we're concerned with, and that is whether the person's a follower, an opinion generator, a leader, or have four-person capacity. In this case, we think Mr. Eakes demonstrates the characteristics of leadership and opinion generation. He will be a leader on the jury. If I had to guess, if he were to be left on the jury, I would think that he's probably going to be the foreperson.
Mr. Moore.
Yes, thank you, Your Honor. I'm somewhat ambivalent about one of my choices for preemptory. I would have been inclined, as Mr. Orrick was, to let Mr. Fortino go for other reasons, and some of the same reasons that Mr. Orrick has expressed. However, in this particular case, I believe what the defense would do would be to thank and excuse juror number 5, Mr. Ramirez, and thank and excuse juror number 4, Mr. Reamer, for the following reasons. Mr. Ramirez worked in the San Joaquin Valley for a number of years for an employer, and although he indicates no problems with that employer, I think if we'd had a little more time in the voir dire process, we perhaps could have developed the concept that, for example, he may have lived on the ranch, had a similar life experience as the plaintiffs, and would tend to align himself more with the plaintiffs, even though he was in the position of a foreperson, than he would with the defense side of this case. So from that profile and from an intuitive profile or a feeling on my part, I would let Mr. Ramirez go. As far as Mr. Reamer is concerned, as being a civil engineer, there's nothing in any of the particular information he imparted to me, one way or the other, that would lead me to believe that he would find himself biased or prejudiced one way or the other in this lawsuit. However, there is going to be a lot of expert testimony in this case on causation relative to the flow of groundwater and the contamination of these wells on the property. And generally, I could not take the chance of having a civil engineer who is an expert in that area, in the sense that he's designed storm drains and other drainage facilities, even though he tells me that he does not have a specific expertise in hydrology, second-guessing my experts, who I would call on causation to place the entire blame for this problem on Alberto Cordilone's fill-up station, as opposed to my employer. In other words, the source of the contamination being that particular gasoline site, as opposed to anything that related to the pesticides used on the ranch. So that would be my reasoning in that connection. I'm ambivalent about a number of other jurors, but I'm sure also is my learned opponent, Mr. Orrick, but those would be my reasons for striking those two.
Thank you, Mr. Moore. We're now going to take a moment and let each of the jurors have a moment to respond to how they viewed the jury selection process, and in addition, any information in their background that may have been relevant to this case that was not inquired into by the attorneys. If we could we begin with juror number 1, Ms. Shelton?
One of the things in my background that may have been relevant is, and it was started to be touched on with regard to lawsuits. My husband was sued in his capacity as the owner of the home inspection business on a number of occasions, and one of those times he was forced to pay $1,000. I thought all of them were unsubstantiated because they were based on defects in the home which the homeowner didn't disclose. And I have somewhat of a bias against people who sell things and don't disclose everything that is potentially wrong with the property. Other than that, I think my background was pretty much exposed.
Mr. Fortino, you were excluded by a number of people. Was there good cause for that?
No, actually, well, as to Mr. Moore, yes. As to Mr. Orrick, no. Mr. Moore started to probe, but didn't go on. If he'd asked me the right questions, he would have found out that amongst the studies that I had either personally participated in or became aware of, that due to the toxic pollution in the Soviet Union and now Russia, that there was some correlation with personal injury. While I wasn't personally sure of the types of chemicals involved, the number of peoples, or the probabilities, I was certainly aware that there was a correlation. I also had a governmental bias, that any expert that would have relied upon government studies I would have found certainly somewhat suspect, based upon my consulting and work with them in the past, and knowing their inefficiencies. One thing to Mr. Moore is that he knows how to put somebody on a hot seat by saying, I'm going to question you next, and then give a dissertation before doing it. There's a certain amount of anticipation there.
Mr. Williams, if I could inquire, how did you view the jury selection process?
Well, Mr. Orrick was probably correct in striking me because I don't like Mexicans. The reasons are is I think that they're lazy, look for the easy road, and drink too much. Also, I once lost a pay raise because of the UFW strike. The office I manage does a lot of agriculture, agribusiness lending. And I also don't like environmental laws. I think they're a bunch of garbage. However, I do like kids and would kill anybody who would harm a kid.
Mr. Reamer, juror number 4.
The three aspects I guess I would comment on as far as not being revealed. Both of them, Mr. Orrick came close but limited his questions in such a way that the information was not elicited. He asked, for instance, of the women jurors whether they personally had experienced any miscarriages. assuming that if any of the men jurors' spouses had miscarriages, that we would not be similarly affected. And in my case, my firstborn was lost by miscarriage. And similarly, regarding bias towards Hispanics, the questioning was phrased in terms of through one's employment had one acquired any such bias, and thus excluded the experience in my character's case, in which my wife was robbed several years ago by Hispanics at gunpoint. And those might have been situations that the attorneys would have been interested in.
Thank you. Juror number 5.
I think that they were both correct that because of my background and being a Mexican American that I would be favorable towards the plaintiff. I will reiterate what juror number 4 said, and that is that there was our third child was lost in childbirth, and it seemed like the way he asked the question, he didn't direct it to the men, and therefore I didn't respond. That's the only part of my background that didn't come out.
Juror number 6, Mr. Eakes.
Yes, in my work in the citrus industry, I have a contact with many of the Mexican American people or Spanish people in the packing houses and also in the picking. So I've had a lot of contact in that regard. In addition, in Delta, this small town in western Colorado, there was a sugar beet factory there. Mexicans were imported for labor. And in both cases, there in Colorado and here, I've had experiences like I have had with many other people. There are some great Mexicans and there are some bad ones, just like there are great Caucasians or Chinese, whatever you want. And so that in that regard, although who can say whether I'm prejudiced or not, I don't believe that I would have had a prejudice against them in spite of that background of being raised in that area and contact and work.
Juror number 7, Ms. Tobey.
Okay. My mother is Hispanic, and I have been diagnosed as being in the early stages of multiple sclerosis, and I believe that environmental factors such as chemicals in the environment have contributed to that disease. Ms. Christmas's husband was a student of my husband's at UCR.
And Mrs. Christmas?
I was surprised that no one asked me about my child with congenital heart defect and what I thought the causes of that were. That might have been related. Otherwise, there's really nothing in my background.
In this particular exercise, we have restricted the attorneys in terms of the amount of time they have to question the jurors to approximately 20 minutes. How artificial a situation is this for you?
I would at least have an hour to 2 hours to voir dire a jury as opposed to a 20-minute limit. And as the court has noted, I went over my limit. I could have easily spent more time. There was a lot more questions that I was thinking about for Mrs. Tobey and perhaps Mrs. Christmas, but you just run out of time. It's artificial. Even in the case of a civil jury on a
Voir dire within your courtroom. Would you please stand?
Yes. I do set time limits, and I evaluate the case as to the length of time. I certainly don't have any evaluation as to the importance of the case, because all cases that come before all judges are important, so we don't do it in that instance. But if it's going to be a 3, 4, 5-day case, the attorneys in voir dire will not get as much time as they would, say, if it's going to be a 3-week or a 4-week case. Now, in this particular case, after the voir dire by the attorneys, you indicated to us that the case may take as long as 3 or 4 weeks. I would, under those circumstances, allow more time. However, in any event, the attorneys know what their time limits are, and I think it's very important, because then they're going to have to concentrate on what they believe to be important rather than be frivolous and just waste their time and try to talk to everyone, and if they have the time to do so, fine. So I think time limits are important. However, they should not be so arbitrary that it becomes meaningless.
Mr. St. Germain, in talking about time and the efficient use of time in jury selection, have you ever had any experience where jury questionnaires have been used to obtain a lot of this information without having to speak directly to the jurors? And what success have you found in that regard?
Yes, I think I should take a moment to define it because most attorneys probably haven't come across a jury questionnaire, because most jurisdictions don't use them, and the ones that do use them, the attorneys aren't aware that they're available, and they end up sitting in the jury commissioner's office or the jury assembly room and nobody looks at them. But the ones I've seen are kind of reminiscent of a loan application form that you'd fill out at a bank or a credit union, only if you can believe it, they go into a lot more detail. And the main advantage comes when you stop to think that to the average prospective juror, this is a completely alien and a completely intimidating process. They're literally fish out of water. They've seen Perry Mason on TV and they know what happens to people when an attorney asks them questions. So their brains aren't going to be working in top form when they're being asked these questions. A good example would be during the exercise we just saw, the question was thrown out about union affiliation. And we got 8 blank looks and a couple of negative shakes of the head. But according to the biographical information, we had a Teamsters union member and another prospective juror whose father was a union man all his life. That's the kind of thing that a juror will forget in the heat of being asked questions live. But if they can sit down and fill out this questionnaire, they have all the time in the world to fill it out, you'll get a lot more detail. And if an attorney can get a hold of those questionnaires and see that detail, they can eliminate probably 80 to 90% of their voir dire questions, and in many, many cases, they can make a decision as to who they're going to issue their peremptories on just from the questionnaires. And one other advantage they have, if it's an important case and you have a staff working for you of, say, investigators, going into detail like this in a courtroom, you'd allow the juror to tell you what city they live in, but on the questionnaire, it's going to have their home address. On a lunch break, you could have your investigator go out, and if they have a "I'm proud to be a member of the Lions Club" sticker in their front window, and of course it's a federal offense to go through their mail, but if your investigator happens to glance into an open mailbox and see a half dozen magazines from environmental organizations, at 1:30 you can return to your voir dire with your Lions Club pin in your lapel and all of your notes in your Save the Whales folder, and just perhaps affect the outcome of the trial subconsciously in that way.
Mr. Hudspeth, you're the veteran of many civil trials. You're confronted with this avalanche of information. How do you keep track of it?
One should use a grid square method on a large yellow pad. If there are 8 jurors, you make 8 boxes. 12 jurors, you make 12 boxes. Then I like to use the lawyer's savior, the Post-it note. And I will put 3 or 4 Post-it notes in each box. Then I use abbreviations as I question each juror in those boxes. I like to use a minus for someone that's negative to my client, 0 for a neutral, and a plus if I think that individual is already biased in my favor, my client's favor. Then I question the individuals who have zeros or minuses in the box. I take down notes on the Post-it note so that if that juror is excused, I can put another blank one in its place. I think that in that manner you keep your part of the counsel table looking very neat, very efficient, and I've had many comments from jurors about that. You aren't constantly changing pages in a pad of paper. I think the Post-it notes are a very good way of doing it.
Thank you. Mr. St. Germain, I want to return to you, but I don't want to ask about note-taking. In this particular trial, we had a number of legal issues that might have come forth, but not much discussion of the law with the jury. Did you ever use the judge's instructions or the proposed instructions that will be given at the end of the case in the course of your jury selection?
Absolutely not. As far as I'm concerned, it's verboten. Even when Mr. Orrick went so far as to talk about preponderance of the evidence, I would have been on my feet objecting that that's improper voir dire.
What about both attorneys as they went through their rendition of the facts and asking for a response to the facts? Isn't that asking them to prejudge the facts in the case as opposed to the law?
Oh, absolutely. I was kind of shocked that Dave wasn't on his feet objecting when Stan started out by talking about the 3 kids and how they get sick. And it just wasn't voir dire.
Thank
Simply
you.
foundational.
Right.
Thank you. I think what we've learned, ladies and gentlemen, is that a jury trial is a very human endeavor. As Anthony Amsterdam, a prominent Stanford University defense attorney, once pointed out, this is so largely an intuitive art that there's really very little that's safe to say about it. Counsel very often, more often than not perhaps, rely upon and give credence to their instincts. All other things being equivocal, the attorney, the advocate, may properly be governed by what he likes, what he feels, or what she perceives about a prospective juror. Oftentimes, you ask yourself the question, is this someone that I would like to sit down and have a meal with? Am I communicating with this particular individual? Subtle reactions of dislike to a juror are often the basis of half-perceived perceptions. Often relatively reliable signs, however, as to what the jury or the juror will likely do in a particular case. In any event, the more counsel likes a jury and feels comfortable with that jury, the better he will project his case, the more confidence she will have, the fewer sleepless nights. On behalf of the Leo A. Deegan Inn of Court, I want to thank you for your attention. Court is adjourned.
This isn't what I want either. Maybe I'll call Susan.
Susan Bagley. Oh, hi, Sam. How's it going?
Listen, I got a client coming in this afternoon who's hopping mad because his daughter broke a tooth in a restaurant and he wants to sue for damages. I'm trying to track down some case law, but I'm not coming up with anything that fits. Restaurant is not even listed as a topic in the digest. So I thought I'd look into that ALR computer system you told me about. Do you have their phone number?
ALR and CD-ROM? Oh, sure. Hold on a sec. I'll just do the search. Let's see. Broken tooth and restaurant. Okay, here we go. Liability for injury by foreign object. Injury by food containing related object. Okay. Hello, Sam? I just did a quick check and found some material where the plaintiffs also broke their teeth. Do you know if the daughter broke her tooth on an object totally foreign or somehow related to food?
Well, I believe it was some sort of a bone in some soup, so I guess that's related.
Well, let's see. You need to determine if it was natural or foreign to the food. Oh boy, there's a whole bunch of stuff on a reasonable expectation test.
That's perfect. How did you find that?
I just looked it up on the ALR CD-ROM. It's right here on my desk. Pretty fast, really.
Fast? That was astounding. I owe you one.